A heated legal battle is unfolding that could redefine how artificial intelligence intersects with copyright law, and Warner Brothers Discovery is on the brink of a significant victory. The dispute centers on allegations that Tesla unlawfully used visuals from the film Blade Runner 2049 to create AI-generated images for promotional purposes without the proper licenses. Yet, what many don't realize is how complicated and nuanced the situation really is. Especially when it comes to the roles and responsibilities of the companies involved. The controversy began during Tesla's lavish reveal of its robo-taxi last year, held on a Warner Brothers studio lot. During this event, Elon Musk made a striking entrance in what he called a cybercab, and then displayed a haunting image of a lone male figure clad in a trench coat, gazing over the desolate orange-hued ruins of a city. Alcon Entertainment, the production company behind Blade Runner 2049, claimed this image was clearly intended to be perceived as an official still from the film. Specifically, a scene depicting Ryan Gosling's character exploring a devastated Las Vegas. Here's where it gets controversial. Alcon alleges that Tesla took stills from the movie and fed these into an AI image generator to produce unapproved promotional content. This raises a fundamental legal question that hasn't yet been fully settled. Does copying parts of a copyrighted work to generate new visuals through AI count as copyright infringement? The court's responses so far hint at the complexities of policing AI's use of creative content. In a recent ruling, the court dismissed several claims against Warner Brothers Discovery. One key claim accused the studio of handing over high-resolution movie images to Tesla for the robotaxi event. But according to the order, this accusation lacked supporting evidence. Similarly, a claim that Warner Bros. Discovery had a legal duty to prevent Tesla from using Alcon's intellectual property at the event was rejected. Although Alcon had asked the studio to stop Tesla's use of Blade Runner 2049 imagery, the court found that such a request did not grant Warner Bros. Discovery the authority to enforce this or control Tesla's actions. Judge Wu wrote in the decision on September 11th that allowing Musk and Tesla to pick and choose content from a library does not amount to Warner having a right to stop, limit, or supervise them. This highlights the tricky balance between intellectual property rights and the extent of control or supervision one party can exert over another in partnerships or collaborative settings. Interestingly, Tesla had refused permission to use Blade Runner 2049 stills just a few hours before the event. According to the lawsuit, Tesla allegedly responded by inputting movie images into an AI generator to sidestep these restrictions, a move viewed by Alcon as a direct assault on their intellectual property rights. Yet, the court's order notes another obstacle for Alcon. Neither the studio nor Tesla appeared to have gained any direct financial benefit from this alleged infringement, a factor that often weighs heavily in copyright cases. Despite these setbacks, Alcon still has the opportunity to amend its claims concerning direct and vicarious copyright infringement. Warner Brothers Discovery's involvement could prove instrumental as Alcon tries to solidify its case and navigate these complex accusations. One important point that tends to be overlooked is that Warner Brothers Discovery remains under claim for contributory infringement, essentially accused of enabling Tesla's alleged wrongdoing. Earlier this year in April, the court refused Tesla's request to dismiss the direct copyright infringement claim, citing several similarities between Tesla's promotional visuals and stills from Blade Runner 2049, which supports Alcon's contention. Alcon's drive to pursue this case also ties into bigger strategic interests, notably an upcoming television series based on Blade Runner 2049. Protecting the integrity and exclusivity of the film's imagery is critical in maintaining value for its expanding franchise. At a hearing earlier this year, when asked about Alcon's hopes for the outcome, their attorney shared a revealing insight. Part of their goal is to clearly establish that the company distances itself from some of the parties involved, presumably to protect its own reputation and business interests. So here's the big question for readers and industry watchers. Is this legal struggle simply a classic case of copyright protection in the digital age? Or does it signal deeper tensions around how AI technology challenges traditional ownership and creativity? What do you think? Should companies like Tesla be allowed more freedom in using AI for marketing? Or must creators fiercely guard their works against any form of replication, no matter the tool used? The debate is wide open, and your perspective could add an important voice to this evolving conversation.